Hello, everybody, and I would like to welcome you to this seminar in the Peking University School of Transnational Law, Beijing 大学国际法学院 Law and Humanities Seminar Series. My name is Norman Ho. I teach at the law school and convene this seminar series. We're very privileged and honored today to have as our guest speaker Professor Jinan Bastaki, who serves as Associate Professor of Legal Studies at NYU Abu Dhabi, New York University's Abu Dhabi campus. Professor Bastaki is a scholar of international law, focusing especially on public international law. And within public international law, she writes on human rights law, refugee law, citizenship and law, as well as forced displacement issues. She's published in various journals in her field, and of note, one of her papers on nationality-based detention of migrants was awarded the International Committee of the Red Cross and the International Institute of Humanitarian Law's Best Essay Prize. Prior to her appointment at NYU Abu Dhabi, Professor Bastaki served as Associate Professor of International Law and also the Vice Dean of Research and Graduate Affairs at UAEU, United Arab Emirates University. She's also held appointments at Oxford, Oxford's Center for Socio-Legal Studies as a visiting scholar, and was educated at the London School of Economics and Political Science, where she received her LLB, the University of California at Berkeley, where she received her LLM, and the University of London, where she received her PhD. Professor Bastaki will be speaking to us today on the topic of the responsibility to suppress and prevent genocide under international law. She will speak for up to 40 minutes, and then after which we will open the floor for questions and answers. I would also just like to note proactively that this event is being recorded by the Peking University School of Transnational Law. So without further delay, I would like to now give the floor to Professor Bastaki. Thank you.
Perfect. Thank you very much, Professor Ho. I wanted to thank you firstly for the invite and to Peking University School of Transnational Law for inviting me and for hosting this very important talk. Before starting, I'm just going to share my screen, just maybe to have a presentation to make it easier to follow along. Just want to ask, can you see the presentation?
Yes.
Perfect. Okay, so today I'm going to be talking about the duty to prevent and to suppress genocide in international law. As many international lawyers would know, different treaties obligate states to prevent certain violations. The Genocide Convention is not the only one, but obviously due to current events, most notably in Gaza, this duty to prevent, not only in Gaza, obviously also in Myanmar, this duty to prevent is now much more salient in terms of what is that duty to prevent, which states have the duty to prevent, and who does it extend to. And so in this presentation, I'm going to be talking about, firstly, just general international law and the duties to prevent, even before talking about the Genocide Convention. I'll particularly be speaking about Common Article 1 of the Geneva Conventions. And then I'm going to be talking about the Genocide Convention itself, what it obligates states, and then what is the scope of the duty to prevent and to suppress. So when we talk about just a general duty to prevent violations, so this is, without the Genocide Convention or, the risk of a genocide occurring, again, international lawyers know the very famous, Corfu Channel case in which British ships were damaged due to the explosion of mines. People were killed, and they had accused Albania of placing these mines there. The International Court of Justice did not agree that had occurred, but that Albania had known, and just based on that knowledge, that they had the obligation to prevent certain conduct by another state, or at least to prevent the harm that would have occurred. So this is without, Albania being the direct perpetrator or the one with the primary obligation, but they do have this the obligation to prevent. So this is just broadly, we find this obligation in international law to prevent certain conduct or certain harm that would flow from certain conduct. And, the ILC and their draft articles, they also state that, states may be required by their own obligations to prevent certain conduct or harm that would flow from such conduct. Now, we also find this duty to prevent in the 1949 Geneva Convention's Common Article 1. So Common Article 1 basically states that the high contracting parties undertake to respect and to ensure respect. So it's the latter part that that is seen to give rise to the duty to prevent, or at least not to be complicit in. So this part of ensuring respect for the present convention in all circumstances. And we see the ICJ expand on this point in the Nicaragua case, where the court basically recognized that the obligation in Common Article 1 entails that the parties should not encourage, they should not aid, they should not assist in the violation of the Geneva Convention. Moreover, the ICRC, in their commentary on this article, they state that states have an obligation to do everything reasonably possible in their power to prevent and bring an end to such violations. And so this is kind of what it means to ensure respect. And this relates obviously to genocide, because while this threshold for proving genocide is obviously very high, it's the intent, it's the dolus specialis that kind of makes, gives it this high threshold. The acts of genocide, aside from the intent, are either war crimes if committed during times of war, or crimes against humanity if outside of that. And so this is what's important to consider. And the ICRC also, further expands and says that over here, the element of intent is unnecessary. So if we look at the ILC draft articles on state responsibility and the responsibility for aiding or assisting in a wrongful act, in the commission of a wrongful act, there is awareness of the circumstances of the wrongful act, but also the intent to facilitate it. Whereas over here, this element of intent does not need to be there, and so simply giving financial or material or other kind of support with the knowledge that it would be used to commit violations of IHL, and so even though it might not be considered aiding in the commission, or aiding or assisting in the commission of the wrongful act, it would still it would still mean that the state has violated the Geneva Conventions, even without the intent element. We also see that the UN Human Rights Council, when commenting on the situation of human rights in Yemen, including the human rights situation in Yemen, including violations and abuses since 2014, basically said that one of the things that has to be considered is, knowledge of facts or knowledge of past patterns that these weapons would be used to violate international humanitarian law. So it's not simply that the state can just put its hands up, so to speak, and say that, well, we did not know that the state was going to be using these weapons in order to violate international law, if it had happened in the past, that there was a pattern of this happening in the past. The state cannot, again, put its hands up and say that that they did not know that these weapons, for example, would be used. So we already have this kind of broad duty to prevent, as I mentioned, broadly international law, as well as you have it in the the 1949 Geneva Convention's Common Article 1 that places this obligation upon states. So the duty not to be complicit, not to aid, not to assist in violations of Common Article 1, but also to do everything in their power to try to prevent. And everything in their power obviously depends on what the state is able to do. They have to be legal means and so on and so forth. But this is also, as I mentioned, relevant to genocide because those acts that are acts of genocide are also considered violations of IHL, also considered crimes against humanity. So when we come to the Genocide Convention, so we have, two articles that mention prevention and or suppression. So Article 1, which says that, the contracting parties confirm that genocide, whether committed in time of peace or war, is a crime under international law, which they undertake to prevent and to punish. And then you have in Article 8 that a contracting party may call upon the competent organs of the UN as they consider appropriate for the prevention and suppression of acts of genocide. Now, what is actually interesting here is if you look at the travaux préparatoires, we don't actually see a lot of discussion of what is the scope of that duty to prevent. So even kind of going back to that, there's nothing really that tells us what does it mean for states to work to prevent genocide. What are they actually obligated to do or not to do? And the other articles in the Genocide Convention, they mostly talk about the latter obligation, which is to punish. And so again, we don't have a lot of explanation, a lot of detail on what it means for states to prevent or to suppress genocide. Now, there have been, some states that kind of contested whether the responsibility to prevent is only permitted under Article 8. So we have over here Article 1 and then Article 8. So there are some states, this is in Bosnia v. Serbia, arguing, mostly Serbia, arguing that this obligation to prevent is basically subsumed under Article 8. And basically contracting parties may go to the United Nations, General Assembly, Security Council, and they are the organs that will take whatever action that they consider appropriate. And the court obviously responded to that point, but really the Bosnia v. Serbia case is the first case that we see in which we have an explanation, a breaking down of what the duty to prevent actually entails. And in that case, obviously, because the ICTY had made a finding of genocide at the Srebrenica massacre, that is the only act of genocide or circumstance of genocide that the court decided to look at. So when Serbia was arguing that this responsibility to prevent is only permitted under Article 8, the court very clearly said that actually Article 1 has its own scope. And even if you call upon any of the organs of the United Nations, it doesn't mean that state parties are actually relieved of their obligations. So that means even if the General Assembly, passes a resolution that says you have to sanction the offending state, for example, or maybe the Security Council does the same thing, individual states are actually not relieved from that obligation to take the action that they can to prevent the genocide occurring while respecting the United Nations. So basically, any action that is taken by the United Nations does not negate, does not preclude, does not relieve any of the states with this obligation from doing what they can in order to prevent genocide. So in the next kind of slides, what you're going to see are basically some key quotes from the Bosnia v. Serbia case, as I mentioned, because this is actually the first time that we actually have a case before the ICJ in which state responsibility for genocide is being examined, and the scope of the duty to prevent is also being examined. So what you're going to see in the next slides, I'm going to explain them, but it's basically quotes from Bosnia v. Serbia, where the ICJ is explaining what the scope of the duty to prevent is. So states, obviously, they can either be complicit in genocide or they can fail to prevent genocide. So in one, they are actively contributing to genocide, and in the other, they're just not stopping it from happening. And so complicity is a negative obligation, right? So states have to not do certain things. They should not provide the means to enable or to facilitate the commission of the crime. Here, the mens rea is a bit higher than failure to prevent. Here, the state has to know of the intent to commit genocide. And the responsibility begins from the moment that state became aware onwards. So once the state became aware that there is an intent, right, to commit genocide, then the state's responsibility is engaged. And from that moment, the state must not provide the means. Now, for the failure to prevent, which is our topic here, is the mens rea element is less than knowledge that genocide is going to happen. So similarly, the responsibility begins when the state learns or should have normally learned of the risk of genocide. Now, this is obviously important because it takes us back to the Corfu Channel case in which the state said that, in which the ICJ said that, well, Albania must have known, right? And over here, if you should have known, should have learned of the risk of genocide, then the state's responsibility is engaged. And this is important, right? So we see, for example, with Myanmar, we see with Gaza, numerous kind of reports by independent human rights bodies, special rapporteurs, Amnesty International, Human Rights Watch. You have all of these independent organizations sounding the alarm or just outright making a finding of genocide. And so you have here when the responsibility kind of begins. Now, certainty that genocide will be committed or is underway is not necessary. Only awareness of the danger, right? So here it's you're aware of the risk, not of the certainty. So there's a risk that genocide might occur. Then again, the state's responsibility is engaged at that point. Now here, this is what's the interesting part. So what is the scope of, state responsibility? Now, states have the responsibility to employ all means reasonably available to them so as to prevent genocide as far as possible. And this is obviously very important because, again, it's very broad. All means reasonably available to them, right? So it doesn't just limit it to military means or financial means, right? All means reasonably available to them. The ICJ places a further responsibility on those states that have the capacity to influence effectively the actions of the persons or likely to commit or already committing a genocide. And so if you're a state that has particular influence, particularly close ties to the state or the persons, the state organs that are, accused of committing genocide or that will commit genocide, then that state actually has a heightened responsibility in relation to preventing the genocide from occurring. Now, this responsibility depends on the strengths of whatever link the state might have. So as we mentioned, it's almost like there's a spectrum. If you are a state that has incredibly close links, that you can leverage those links in order to prevent the genocide, then you have this heightened responsibility. If you're a state that might not have the capacity to influence them. So perhaps your trade is very low, there's no kind of military trade, there's nothing really that you can leverage. The responsibility of that state becomes, or at least what it seems to be saying here, is less than the state that has that capacity to influence. And it's interesting that also the ICJ here says, links of any kind. So they say financial and political links, but then they add and they say links of any kind. So really emphasizing the point that states have to leverage whatever they can in order to prevent the genocide from occurring. Now, when finding that Serbia was responsible for failing to prevent, it was because Serbia was in a position to influence the perpetrators of the Srebrenica genocide. And this is because the strength of the political, military, and financial links. So this is basically what the court identified as the links that could be leveraged, but it's not an exhaustive list. This is what Serbia could have done, what they could have leveraged in order to influence the perpetrators of the genocide, and they did not do so. And again, this emphasis, any state party in a given situation has in its power to contribute to restraining, again, in any degree. So this really kind of puts responsibility on the vast majority of states, really to examine their relationship with the state that is being accused of, committing genocide or intending to commit genocide, that they have to, in a sense, review their links and actually review what can they use in order to influence that state, in order to prevent or to suppress the genocide from occurring. We see that in many different statements, the court is construing this capacity to influence really very, very broadly. So even when they cite certain specific things, political or financial, they then add or any link, restrain to any degree. Right? So basically anything that a state can do that is legal, then the state is actually legally obligated to do it under the Genocide Convention. And the important thing also is the duty to act, not even to guarantee a certain outcome. So the court says, the obligation to prevent places a state under a duty to act, which is not dependent on the certainty that the action to be taken will succeed, or even the likelihood of that outcome. And obviously, the court is envisioning that if every state revises their links with the offending state or with the allegedly offending state, that the combined efforts of all of these states, each complying with their individual obligation to prevent, that is what's going to avert the commission of genocide. So it's not for states to say, well, look, our strengths aren't that strong. We perhaps simply have a trade deal. But if those are the only links that a state can leverage, what we kind of understand, or what we can extrapolate from what the ICJ is saying, that state individually is obligated to leverage that kind of link and that kind of influence. And therefore, if all states do that, then this is more likely to help to avert the commission of genocide. And obviously, this is due to, as we know, the kind of the status of genocide as the crime of crimes. And so because genocide is, such a horrific crime, then again, states are obligated to use, again, everything in their power in order to prevent the genocide from occurring. Now, as I mentioned earlier, Article 8, specifically mentions, the suppression, right? And this is the suppression of the genocide. So assuming genocide is underway, then the states, or, at least according to this article, the United Nations can authorize, a certain action to prevent and to suppress them, to suppress the acts of genocide. What's interesting is that there is a Soviet proposal that would have required the Security Council to intervene in all cases of genocide, but this proposal was eventually rejected. Now, if we look at different cases, so this is kind of the case of Bosnia v. Serbia, where the court emphasized obviously the duty to prevent, And then we also have the language of suppression as well. So in the Gambia v. Myanmar, this is in the, I believe, the provisional measure stage, or actually, maybe I'm mistaken. It might be when discussing the jurisdiction. So over here, the court said that, all state parties to the convention have a common interest to ensure the prevention, suppression, and punishment of genocide. And this was also repeated in the first provisional measures that the ICJ issued in South Africa v. Israel. And obviously, if we look at the duty to suppress, it's an extension of the duty to prevent. We cannot expect that a state should try to prevent, and then once the genocide is underway, say, well, it's already happening, I'm not preventing it anymore, we're just going to go to the punishment. It's an extension of the duty to prevent. So if the genocide is underway, then states also have to try to suppress it as much as possible. And we also see this obligation in state obligations to bring about an end to the violation of peremptory norms, which I will also be discussing. So as I mentioned, the prohibition of genocide, so that we have the Genocide Convention and the court kind of explaining in the Bosnia v. Serbia case the scope of the duty to prevent. And South Africa really very much relied on the Bosnia v. Serbia case to make the case for provisional measures. And we know that in that case, the ICJ actually issued to date 3 provisional measures against Israel, which so far Israel has not complied with. In Nicaragua v. Germany, so Nicaragua actually made many arguments based on Bosnia v. Serbia, because in that case, it's not as Germany as the primary offender or the direct perpetrator of genocide, but really as that third state. And so Nicaragua's case against Germany was really about Germany's failure to prevent. That case was based on violations of Common Article 1, so that Germany is not ensuring respect for the convention. And also violations of the Genocide Convention, because Germany has this obligation not to be complicit in, and also they have the obligation to prevent genocide. Now, in the provisional measure stage, the court declined to issue provisional measures at that time. And the reason in the Nicaragua v. Germany case was because it appeared that the court was convinced by Germany that their weapons, that they were not supplying Israel with war weapons, and that they had a robust system of checks and balances that would prevent Germany from transferring any weapons that could be used in the violation of either the Geneva Conventions or the Genocide Convention. And it seems that, again, at that point, the ICJ was convinced to the degree that it was not urgent to order provisional measures. Obviously, this was also very much critiqued because, as we mentioned before, even if that were the case, and there's a lot of dispute as to whether that really is the case, Germany's obligations are much wider than simply not transferring weapons. And so this was kind of an interesting critique of the ICJ not issuing provisional measures. But there's also been a lot of talk about the fact that the ICJ was being pragmatic. They can't issue provisional measures in all cases, and so on and so forth. But this is something that, of course, is going to be examined in the future on the jurisdiction as well as the merits. But to come back to kind of the duty to suppress, again, as an extension of the duty to prevent, the prohibition of genocide, as I mentioned, is considered a jus cogens norm, right? It's a peremptory norm of international law. And as we know, that the states are obligated to bring about an end to the breach of peremptory norms. Now, the ILC, the International Law Commission, says a lot about this, but I've kind of summarized it here, that, that bringing an end to these serious breaches of the obligations have to be done through lawful means. Unilateral measures are not prohibited, but emphasis on collective measures. So, and this includes ad hoc arrangements by a group of states. So it's not necessarily through the United Nations. It can be other ad hoc arrangements. As I mentioned, the collective system the UN has preferred. Any other international organization can do so. But the Wall case also suggests that there's an obligation on individual states to make efforts to bring situations created by the breach to an end. So as we know, in the 2004 Wall case, the ICJ stated that the building of the wall was illegal, and then it also expanded upon what are state obligations in that regard. And when talking about state obligations, that states, should not recognize as legal, that states should not, aid and assist, and so on and so forth. So states actually have individual obligations in order to help to bring about this breach to an end. And so this duty to kind of to suppress, as I mentioned, is this extension of the duty to prevent. So as the violation is occurring, then states have to also try to prevent this ongoing violation, to stop it wherever it actually is. And the ILC also kind of expands on this when they talk about, responsibility of states for internationally wrongful acts. They say that, the breach of an obligation requiring a state to prevent a given event occurs when the event occurs and extends over the entire period during which the event continues and remains not in conformity with that obligation. So when we talk about the responsibility to prevent and to suppress, in Bosnia v. Serbia, the ICJ almost exclusively used the term responsibility to prevent. But obviously, we can assume that this also means the responsibility to suppress, and the state and the ICJ mentioned this term quite explicitly in the Gambia v. Myanmar, as well as the provisional measures in South Africa v. Israel. And as we said, this obviously makes logical sense. It wouldn't make sense to obligate a state to prevent and then to punish afterwards, but not stopping something while it is occurring. And so this is kind of the broad scope of the obligation to suppress and to prevent. So before kind of summarizing, I wanted to give maybe a few examples of what it means for states, and also looking at what certain states have actually currently done in order to comply with their own obligation to prevent. We see, for example, this was a year or two ago, we see in Holland, for example, the Dutch High Court, I believe, prevented the transfer of certain weapons, by the Dutch government to Israel, based on the ICJ's provisional measures. And so in that case, again, we see, again, the ICJ's provisional measures having an effect domestically, but those states, or at least the courts in those states, really taking that legal obligation to prevent, at least somewhat seriously, and trying to prevent their own government from transferring certain weapons. Even in Nicaragua v. Germany. So even though the ICJ did not pronounce any kind of provisional measures, they did actually emphasize states' obligations under the Genocide Convention, that they have the duty to prevent, and that they're obligated to ensure respect of Common Article 1. So even though they did not issue the provisional measures, they still made it a point to emphasize states' individual obligations, and it also kind of kept it open because they didn't basically remove kind of the case itself. So it's possible, perhaps, that Nicaragua could request provisional measures again, based on a change of circumstance, based on perhaps providing evidence that maybe Germany is providing these war weapons, or is failing to prevent in other ways. We also have, for example, one of a Japanese corporation, Itochu as well, that had a trade deal with Elbit Systems, which kind of provides technology to the IDF, the Israeli army, kind of basically withdraw from that agreement, even though it is a corporation, so it's a private entity. This was on the basis of kind of the Japanese government, and part of the reason that was stated was explicit, that they do not want to be in violation of the ICJ's provisional measures. They do not want to be seen to be, or they do not want to be failing to prevent. As I mentioned, in Nicaragua v. Germany, even though the court did not issue provisional measures, after that we see the UK suspending the transfer of around 30 weapons licenses. Now, there's over 300, so it's not the majority by far, perhaps just something like 10%. But again, we see now states thinking, well, the awareness, as I mentioned before, that states have the awareness that there is, if you're being conservative, that there is a risk of genocide, right? And so the states already have this awareness. And so the responsibility to prevent the genocide, to suppress it if states believe that it is happening, now their responsibility is engaged. And so we see in all of these different cases that to various degrees that certain states are attempting to in very small ways, I mean, in my opinion, perhaps not enough, but in very small ways, trying to comply with what they read as their obligations under international law, really based on the provisional measures that were ordered, as well as the provisional measures that were not ordered, but where the ICJ still emphasized that states have a certain duty. And so just to kind of to summarize, what are states' obligations to prevent and to suppress genocide? So the state's duty begins at the moment they learn or should have learned. So a state saying that they did not learn would not be an excuse if they should have learned, right? And as I mentioned, we have different cases that are currently, being adjudicated before the ICJ, in which there is a lot of evidence of, again, conservatively, the risk of genocide, if not outright genocide. And as mentioned as well, the failure to prevent doesn't require certainty that the genocide will be or even is underway. As long as there's a risk of it, then the state's responsibility is engaged. States have an individual obligation. It's not that a state can almost delegate their responsibility to the United Nations or to any other international organization. They have to individually use any legal means to prevent and to suppress the genocide. This includes leveraging their political, financial, military links, as well as links of any kind. There's a heightened responsibility for those states with stronger links. And there is a role for the United Nations under Article 8, as well as states collectively, certain international organizations collectively, because they're obligated to bring about these breaches of peremptory norms. And as I mentioned, the duty to prevent extends to duty to suppress. As long as the illegal acts are occurring, then states, they have this duty to prevent and to suppress. And so just in concluding, the Genocide Convention was very clearly kind of drafted with the intention to not only punish the perpetrators of genocide or states responsible for genocide, but also to prevent it from happening. And we can see that in terms of the acts that are criminalized. So, conspiracy to commit genocide, the intent, like this means that the genocide might not have occurred, but there's a conspiracy to commit it. There's an intention to commit it. So even certain acts that are criminalized, right, incitement to genocide, right? So even certain acts that are criminalized, they don't assume that the genocide has actually occurred. And so the Genocide Convention itself also criminalizes the acts that, I mean, states can also use that in order to prevent a genocide from occurring. Bosnia v. Serbia kind of gave us this really broad understanding of the scope of the prevention of genocide. States are legally obligated to take this responsibility very, very seriously. We saw the disastrous consequences in Rwanda and in Bosnia. And so now, with everything as we're seeing in social media, most states cannot claim a lack of awareness in terms of what their support or their lack of using their leverage to prevent is doing. So I'll end here. I think that's 40 minutes. So thank you very much for listening.
Thank you so much, Professor Bastaki, for the very interesting and thorough presentation.